Hi, everyone. Happy Wednesday. Today, we're going to be talking about some of the Department of Labor issues and guidances and things that have changed. So, on the latest guidance on February 9th, the Department of Labor Wage and Hourly Division issued a field assistance bulletin concerning remote employees. And, you know, one of the issues that it was talking about is short breaks or 20 minutes or less for remote employees. And that kind of goes back to the point that right now, employers and employees need to come up with a system where the hours are tracked better. And also, if let's say it's a full-time employee, kind of having a communication between employer and employee and thinking through, that if you get certain breaks when you're in the office, you're entitled to similar breaks at home if you're working from home or another location. And a lot of employees, who I'm talking these days, they all feel like, well, if I'm working from home, I shouldn't be eligible to the same things. Or some of them are concerned that they're losing those actual benefits. But if you look at it from the employer standpoint, I feel like some of the employers are saving on rents, they're saving on potential supplies within the office, and they're also giving their employees better, maybe conditions, and then the employees are able to do more efficiently and they feel more comfortable. So I think it works both ways, but we just really, really have to pay attention to making sure that the employees know their benefits. And I really wanted to go back to Irene on this because I know she knows the specifics of this, and I think it would be very helpful for everyone to look at it today. So Irene, will defer to you on this.
Hi, everyone. Thank you so much, Jane. So we had even more guidance, and I think we've been talking about this for months that we keep anticipating more and more rules to come out, more guidance to come out. This is going to be a very heavy year with legislature and with just new updates, especially as it pertains to employee rights. We saw a big break during COVID. We saw that there was really a stall of any and all new laws that we anticipated coming in. And now, because of that, everything that was pending is being pushed in, but also following COVID, all of these new ways of remote working, hybrid schedules have sparked conversations for possible other changes. And this is one of them. And so the break time, and this does go right into our topic, I believe, 2 weeks ago on breaks that we had. And what we discussed was that break times are mandatory to be given, especially if a shift is longer than 6 hours of at least 30 minutes. And so the employer rather, is obligated to establish procedures by which an employee could take that break. So anything that's shorter than 30 minutes in New York, any break time does not have to be compensated to the employee. Anything longer than the 30 minutes does have to be compensated to the employee. And it also establishes that if an employee works for 6 hours, they're entitled to their 30-minute break. So we've gone over these terms for New York specifically, but then, as Jane had mentioned, on February 9th, there was the update to include remote employees as well, which I'm sure that has come up quite often to the Department of Labor. And I'm sure because of that, they needed this additional protection in order to be able to cover the employees that are remote and or hybrid, because some hybrid employees may have complained that they received some benefits while in office, while they didn't receive those benefits from home. And so under the FLSA, the Fair Labor Standards Act, which is a federal law, the requirement is a 20-minute threshold. So in New York, it's a 30-minute threshold. Under federal laws, it's going to be 20, where the employees are entitled to be compensated for any breaks that are more than those 20 minutes. So it's definitely something to discuss with clients about the difference in New York versus the federal laws, as well as which of these specifically do we have to make sure that we comply with. We can obviously comply with both, but now that we have this limitation of 20 minutes, which is less than New York, some of the conversations we've been having with our clients is how do we amend to make sure that we can satisfy both the federal and the state laws, which are not always one-to-one, although New York does mirror image federal quite a bit, very much not in this case. And then the FLSA went on to further establish that the break time will extend to anyone looking to express milk, which is what we discussed last week on our top topic on our podcast about having to have a safe space to do that and providing all valid accommodations. This is going to be valid and extended for remote employees as well. And so a big question here is, in New York, the breaks are unpaid for anyone looking to express milk, as long as they're relieved fully from their duties. But it seems that the federal laws are a bit, don't look at it the same way and may include it as a break. So it's very important to review that individually. It's very important to see, to make sure that the employer would be eligible under both and would be also providing the correct benefit under both the FLSA as well as under the New York labor law. And then one of the other extensions towards remote employees was under the Family Medical Leave Act as well. And the Family Medical Leave Act establishes that employees have a right to take up to 12 weeks a year of unpaid but job protected leave for various reasons. Adoption of a child, to care for themselves, for medical, any illnesses, for any hardships. And so there are various categories. And so the protections now have extended to anyone who works from home, who is remote, who is hybrid, who teleworks as well. So if a employer is of the size where FMLA is given to their employees, they would be required to do so for any remote employees as well. So as usual, this is a big change, but also a change that needs to be reviewed individually because of, especially here, because of the difference that we found between and discrepancy between the New York requirement versus the federal requirement. This is something that we've been looking into individually with all of our clients, because it's very important that there's a compliance for both. We imagine that New York at some point will come in and will match federal, but just wanted to point that out as well.
Thank you, Irene. This was very helpful. So I think we sort of covered the breaks and also the FMLA for remote employees, because I know some of our clients were asking us about, well, if my employees wants to go on maternity leave, what happens? So thanks for clarifying that, basically now the benefits go to teleworking as well.
Absolutely. So for the FMLA, again, the employer has to be of a certain size because that's a federal
Right.
protection, but there's a similar one under New York laws as well. And again, we anticipate that New York is going to come up and likely either match the federal requirements, which it usually does, but at least for now, we're in this period where there's some question between them. So we need to make sure that we're in compliance with both for sure.
Right. That makes sense. Thank you. Thanks, Irene. You always help us figure out these bulletins that come out.
Of course, and if there's any questions, what an employee status is, if they're remote and so on, these are questions that Jane helps clients with all the time. If there's a question of, again, making sure that these policies are in place, and are you satisfying the law by providing the employee the opportunity to take these breaks, which is much harder if you're in a remote employee. Happy to assist with that as well. With anything that our clients may need.
Thank you.
Thank you, everyone.